We're here on a Friday night, and I don't know. I wanted to come in and talk a little bit about the civil trial, Karen Reed civil trial. Obviously, this is big news right now, very very big news, and I wanted to do kind of break all this down. What we'll see possibly in the civil trial versus the criminal trial, lots of things to get into. So that intro went a lot quicker than I thought it was going to be. I programmed a new intro. I thought it was going to be a little bit longer, but that went quick. But anyway, welcome in, everybody. Make sure to smash the like button when you come in. Subscribe if you haven't subscribed. And we're going to get into this tonight. Let's see, before we get into it, let's look in the chat and see who's here. Carol says it's all behind her now. But the civil suit, absolutely. One more hurdle in this. Hopefully one more hurdle in this. Joy says, hello, everybody. Debbie's in here. Hello to see, nice to see you, Debbie. Rufus is here. What's up? Yo, what's up? Sue is here. Sherry is here. Christy is here. She says, smash that like button. Sherry, hello, Sherry. Hello, Kathy. Hello. Stylin' One, hello. Nice to see you. Jedi Jen, hello. Good to see you. Nurse Corky, good evening. Hello. Karen in the house. Hello. Eminem, hello. Greg says, let's fucking go. Love it. MK, hi, Brian. Excited to see you live. Good to see you. Thank you. It's your first time over here again. If you haven't caught my live stream, sit back and we'll enjoy this one. But let's do this. Let's get into some local news here in Massachusetts first. We had an update in Sandra Birchmore's case today. This dropped at about 5 p.m. this afternoon. I had my friend Todd McGee actually text this article over to me, and I read through it. And let's just take a look. So let me pull this article up here from Boston 25 News. Ex-cop barred for life in Massachusetts over conduct involving Sandra Birchmore. So the curtains are all starting to fall for all these motherfuckers for what they did to Sandra, and deservedly so. Let's see this. Boston, former Abington School Resource Officer Joshua Heel, who was a witness in the federal murder investigation of Sandra Birchmore, has been permanently barred from ever serving as a law enforcement official or officer in Massachusetts. The ban was finalized by the Massachusetts Peace Officer Standards and Training Post Commission on September 25th, 2025. The Post Commission order states that, quote, that Heel, quote, shall never again apply for certification as a law enforcement officer within the Commonwealth of the Massachusetts and shall never seek or hold employment by any law enforcement agency in the state. The action against Heel stems from sustained allegations of misconduct, including the accusation that he lied about a sexual relationship he had with Sandra Birchmore when she was a young adult. The Abington Police Department found Heel engaged, quote, in conduct unbecoming an officer and, quote, untruthful during multiple interviews. Goes on to say, Abington Town Manager Scott Lambie supported the commission's ruling, stating that he was, quote, glad that this is over and behind us and that the outcome that is what we anticipated and we'd hoped for with our recommendation. I think it's probably what's best. Heel met Birchmore in his previous job working as Stoughton Animal Control Unit. His name appeared in an internal affairs report that accused Stoughton police officers of sexually grooming Birchmore when she was a minor. I cannot believe that with all of this evidence that's been so compiling in this case and how this all just got ignored, you know, when Sandra was first autopsied and found, to try to turn this into an unaliving is insane, is absolutely insane. And, you know, and then being able to go over and talk about this stuff like pregnant, you know, we looked at statistics of like pregnant mothers that unalive themselves. The statistic is very, very low. And then the statistic that we looked at of pregnant mothers unaliving themselves by, you know, hanging the way that Sandra was found. I mean, it was so obvious. It was so obvious as to what happened to her. And I can't believe it. I mean, this is some of the most obvious evidence, and it's taken this long to get to, some certain resolve and outcome with the people that have all been involved with harming and essentially killing Sandra Birchmore. It's beyond me. I mean, for Christ's sakes, I mean, I know that the medical system works very slow, and the wheels in our country turn very slow for medical problems. But I mean, justice is longer. Even when you have the most obvious evidence, it just seems the way that this is the way it works. All right, let's read a little bit more here. Heel met Birchmore on his previous job working with Stoughton Animal Control. Let's see. A recording leaked to investigative reporter Ted Daniel last year revealed that former Abington police officer David DePapa said that Heel had intimate knowledge of Birchmore's involvement with the Stoughton officers. DePapa said that Heel admitted to having sex with Birchmore when she was a young adult, stating that the allegations he had exchanged a cat for some oral sex was true. DePapa found Heel to not be credible according to the recording because Josh denied having a sexual relationship with Birchmore during the interview, but had changed his answer in the second interview. This is ridiculous. Birchmore was found dead in her Canton apartment on February 21st, February 2021, although state police initially believed it was a suicide. Federal authorities charged the former Stoughton police officer Matthew Farwell with her murder last summer, accusing him of staging her death to look like she had hung herself. That's exactly what he did. I mean, it is so obvious. I just don't understand. You have a video of Matthew Farwell walking into her apartment, going up, leaving 20 minutes later, and then a couple of days later, Sandra Birchmore's found, and they go, "Oh yeah, she was so heartbroken over everything that she just unalived herself." You've got to be kidding me. I mean, all the evidence is there, and they just drag this out because it's law enforcement officers, and we know how all that is and works in this state. Law enforcement officers caught up in any type of scandal, what do? We cover for them. That just seems to be the norm here in the state of Massachusetts. And it's not only happening here, it's happening in your town too. It is definitely happening in your town too. This is the way that it goes. This is the way that the wheels of justice work for people when law enforcement officials are corrupt and involved in things that they should not be doing. Murder, embezzlements, falsifying evidence. I mean, everything. This is what happens. The unions and the lawyers protect for the bad guys. That's the way it works. Pretty disgusting. Heel maintains he's done nothing wrong. His lawyer, Peter S. Farwell, which is Farrell, I'm sorry, noted that Heel's certification had already expired before the agreement and that the voluntary agreement is not and should not be construed as an admission of fault or liability for any of the allegations asserted by Post or any of the entities. Farrell added that the Superior Court finding on January 22nd, 2024 dismissed Heel did not break any laws and that he would not be a target of any criminal charges in the future. Heel's Massachusetts law enforcement certificate status will publicly be expired. The agreement does not prohibit Heel from seeking employment as a police officer in the state. I don't care what this lawyer is saying about he did not break any laws. They need to federally look into this guy as well and all the major players that were involved in the, grooming, disgusting grooming of Sandra Birchmore. They all need to go down. They all need to go down. Federal, if the fucking state's not going to do it, then the feds need to step in and take these people down. It's ridiculous. Yeah, and that's what it should be too, Debbie. If you lose your certificate, you should not be able to apply to be a police officer in another state. You've broken the law. You've been implemented in a criminal complaint. That's it. You should be done forever in any state. It's the way it should work. But this is what happens, again, when the unions and the lawyers get involved. They get a pass. Might not be able to be a police officer in this state. Might not be able to be a active law enforcement in this state, but it gives you the opportunity to go somewhere else and apply to be a cop. Pretty sick. Pretty sick. All right, let's get into my presentation tonight. Brenda says, ridiculous. One of these mofos need to be held accountable. Yeah, and that's the thing, MG. What is the point of post? You know, if you're saying, like, what is the point of it? The point of it is they, in a technical sense, is they take all this information, they have a hearing, and then they make the recommendation on the findings of the evidence in the hearing, that if a officer is then unbecoming. If you're saying, like, kind of like, what is the point of post? Really? I mean, I agree with you. What is the point of it? Because all it does basically most of the time is come down to protection for these officers. They say, well, you can't be someone here, but you can go off to another state and apply. Pretty sick. Britt's checking in. Thank you so much, Britt, for being here, being a channel member. I appreciate that. Yeah, exactly. Well, yeah, it was expired, but not really taken away. Right. Well, that's just the lawyer talking. That's the lawyer. That's the lawyer covering for heel. And I plan on doing a show on this with Todd. Todd can speak more to post and what happens during those, commission hearings and how this all works out. So maybe we'll get something together going on Monday. We'll have him over here. We'll get Nan up here, three amigos, and we'll go through all of this stuff. So, okay, let's get into my presentation. So I thought today I wanted to talk about the civil trial that Karen is obviously upcoming here. And, we had the first civil hearing the other day. Actually, let's do this. I want to play what Alan Jackson was saying outside. We don't need an echo. So let's play Alan Jackson and civil attorney. So this was the other day out in front of Plymouth. And Alan Jackson speaks again.
Oh, poor girl. So you need a whole change in tactic, right?
I think we're a little offensive during the criminal trial.
How does that work?
I need a full back.
Y'all didn't even let her get a blocking back.
We
can move quicker.
Alan, can you help me understand what an affirmative claim is?
What an affirmative claim is? It's an affirmative claim against the third-party individuals. That's exactly what we intend to bring.
But the idea is to get them combined to save the court time and money.
All the same individuals are involved, so that's exactly right. It's a matter of judicial economy.
Your response to the fact that the judge would make it longer if you do this. You have all these.
Well, of course, because it becomes a bigger case, more voluminous, right? It's a bigger case with more claims, and that's exactly what this case calls for.
Yeah, we're going to talk about that tonight. What is the expected evidence that you're going to see this time around in the civil trial, and what the difference between a criminal and civil trial.
The days of Karen Reed being on the defense are over, right? That's what started today. That's what we're seeking today.
What do you think of the judge say trying to resolve this? Can you resolve this out of
every single civil case should at least have that on the table. Civil cases are built and designed to be resolved if they can be. We'll see. It depends on how reasonable the other side is.
Was that something that you guys would like to do, though? I mean,
Say it again?
Was that something that you guys would like to do, or do you want to make a point?
Anytime there is a civil case, look, civil cases are not about making a point. They're about trying to seek the truth, right? And that's what Karen's going to do with this civil case. We're going to try to get the truth out there. Like I said, the days of her being on the defensive, those days are over.
So you said
everything that you heard in there was basically parroted. Every single word that you heard in there was basically parroted right from Michael Morrissey, right from the prosecutions. They lifted it right off the prosecution's closing argument. And maybe somebody should check the tapes. Because last time I checked, those arguments were put forward in front of a jury, and the jury spoke very, very loudly. Not guilty, and not just not guilty when the jurors were asked, innocent. Those claims are false, and they were proven false, and they will be proven false again. But in terms of what you just asked, should this case be resolved? We're always open to resolution. We'll see. It depends on how reasonable the other side is. Do you plan? We gotta go.
Damon, did you want to say anything? I mean, you've been sort of point person on this, or?
Well, Ellen
Sorry,
says it all as in a perfect way. So, what we're trying to do is make sure that Karen is well defended and that the claims that we have to pursue for her affirmatively are brought in the same proceeding in the most efficient, judicious way so that her day in court is fully and fairly adjudicated.
But if you combine these cases, isn't that unfair to the O'Keefes?
Not at all. Not at all. Part of her defense is that somebody else put her in this situation. And so that's when I said it's not your typical wrongful death action. Karen Reed is in this situation because of the behavior of others. And as Ellen said, she's no longer on the defensive. She's going affirmatively. And we're trying to put all the evidence, all the parties, all the claims in the same proceeding.
How did you decide on who to name in the counterclaim?
I'd love to tell you that, but it's really sort of a litigation strategy point. So unfortunately, I cannot get into sort of discussions behind the scenes.
So do you plan to prove that someone else killed John O'Keefe?
We plan to show that Karen did not.
But that's not the same as proving someone else did.
We're going to let the evidence play out. I'm not able to tell you that yet, but I can tell you that she did not.
How about, can you spell your first last name for me? Colin?
Sure. Damon, Damon, Seligson, Seligson.
Thank you.
There you go. Damon Seligson. Interesting. Let's see. Someone had a question here. Rumor has it that Nan might be joining the civil case. Any truth to that, anyone? I don't know. And I talk to Nan on a pretty regular basis. I haven't heard anything. I don't think that she's what's the word I'm looking for? Maybe like certified to be a lawyer here in the state of Massachusetts. I don't know how that works. So I don't know. If she comes on the Monday show, maybe we can ask that question. But I haven't heard anything. So I haven't heard anything yet about that. Kathy says O'Keefe's are stupid to drop this bullshit case. Yeah, we're going to get into that, and we're going to get into all the possibilities, and we're going to play a little bit of testimony tonight as well. And I think this is going to be a great presentation. So let's do this. Let's get into my presentation that I put together here and go through this and talk about the difference between the civil and the criminal trial, the criminal and civil trial. So I call this kind of like fallen to pieces. This whole thing is just going to fall by the wayside. And I said this the other night, I think the O'Keefes, in my opinion, are going to get their asses handed to them again. They're going to get their asses handed to them. Karen went through 2 criminal trials and then in the second trial, absolutely, completely acquitted of killing former Boston police officer John O'Keefe. Okay, scientifically proven and factually proven, factually innocent. Okay, and now you're going to bring into this civil trial and try to replay that same game again. But I'm going to tell you, civil trials open up so much more discovery. So, my question is, and what I've always said, O'Keefe's, are you ready? You better be ready, because this doesn't exclude you either. This is going to open up opportunities for all of your information. It's all going to get pulled into this civil trial. So let's get into it here. So we have the key difference between a criminal and civil discovery. So in a criminal trial, discovery is limited by the prosecution's duty to disclose exculpatory evidence, and that's the Brady-Giglio, and by Rule 14 of mass criminal procedure. Many documents and witnesses were shielded by prosecutorial discretion, claims of irrelevance, or ongoing investigations. How many times did we hear that? What did they do? They hid x-rays of John O'Keefe that we didn't hear until way into the second trial. There were text messages that were by Michael Proctor that were very limited on a scope. There were communications between the McAlberts and all the information that they had that were very limited in this trial. That all goes away. It's all open now. It's all going to be fair game. So in a civil trial, the parties, Reed versus O'Keefe estate and others can be interrogas, requests for production, depositions, and subpoenas. That's it. When you're called for a deposition, you've got to sit down and answer the questions. You don't have the protection of a corrupt DA anymore. It is all on the table. And I'm telling you, I wouldn't even be surprised if testimony from the criminal trial is brought up and played in these civil trials. I wouldn't be surprised. You know, oh, really? That's what you said? Well, in the criminal trial, here you go. Anything reasonably calculated to lead to admissible evidence is discoverable, and even if it wouldn't be admissible in a criminal case. Okay, let's go to slide 2. So what discovery can surface in a civil trial? Depositions under oath. Expect sworn depositions from all central figures: Brian Albert, Jennifer McCabe, Matt McCabe, Chris Albert, and etc. The state police investigators, you have Proctor, Bukaki, Guarano, and others, Tully, and others that have been involved. We have federal and state law enforcement liaisons and Canton's first responders. Unlike in a criminal trial, defense attorneys in the civil case can ask open-ended, probing questions, and invasive or contradictory answers will be locked into the record. Mary says it should be, especially where the testimony shows that they lied and evidence was destroyed. 100%, Mary. 100%. 100%. So all those little things that you lied about, all those little things that you did to hide what went on that night, is all going to be brought into this. And that's why I said in the very beginning of this, are you ready? Are you ready for it? Are you prepared? And these are some of the most brazen people that I've ever seen in my entire life to go forward with this civil case, this civil trial. Because they're going to be open for it too. Paul, Peggy, all of them. Because Karen's going to countersue. So get ready, because your phones are going to be extracted too. And if there is communication, they're going to show all those communications between Jennifer McCabe, you know, if she's having any communication with John, with Peggy, it's all going to be there. It's all going to be there. We're not going to be shielded by a corrupt DA anymore. It's all going to be on the table. All right. So what's open? So we have phone, text messages, digital records. We have a broader subpoena for now: cell phone extractions and deleted text recoveries. Oh, and that is Jennifer McCabe, Miss I'll delete everything. Google location history, social media activity, and messaging apps. It opens this thing right here to everything. They're going to go meticulously through these phones. So that's why I keep saying, and keep this in the back of your head. Keep this in the back of your head. Are you ready? Are you ready? That's kind of the theme of the show tonight. So the civil court can compel services provided directly, not just filter records chosen by the prosecutors. So you have internal police and DA documents. Discovery can force exposure of internal and fair records, misconduct and discipline in investigating officers. Oh, and whose name comes to mind when we say that? Who is in an internal affairs investigation of misconduct and disciplining investigating officers? Whose name comes to mind in that? Say it in the chat. Let me know. Whose name comes to mind in that? So you have email chains, memos, and communications between Norfolk DA's office and MSP, and we saw some of that already with the leaked emails from, that's right, Bob. We've seen those leaked emails so far and the way that they talked about Karen in this case. Joyce says, oh, let me guess, Proctor. Exactly. Kelly's got it. She knows. Proctor. Yeah, I mean, we'll even get Saraf in there too. Why not, right? Oh, I like this. Juju B says LTL stands lots of love. It's Let's Talk Live, but I'll take lots of love as well too. And then so now we go on to budget investigation costs, and we've already heard most about that already. That's been out in the public. Who authorized what and when? All right, let's move on. Is everybody still with me here? How are they liking this so far? So now you're looking at the medical and forensic expert testimony, and we're probably gonna see a lot of the same players on both sides that came in, and it's gonna cost. And that's what I said. The O'Keefes, get ready, because this is going to cost you a lot of money. A lot of money. You might have to hire some of these experts to come back in and testify in your civil trial. People that were used for the prosecution, people that were used in the defense. So be ready, get ready. So you have full access to autopsy files, toxicology, pathology reports, and cross-examination of the state and independent experts. You get everything now. You get all the medical records. You're going to get all the pathology reports. Oh, and look at that. Cross-examination of the state and independent experts. So number 5, you have civil subpoenas for third parties. That's the bar staff, the neighbors, Canton officials, and even media and insurance entities that can be compelled to turn over records. Institutions like Verizon and Apple will have to turn over the data. They will have to turn over the data. So no more hiding. No more hiding the phone and limiting the scope in the civil trial like they did in the criminal trial. All these phones. And that, again, it's the most beautiful, powerful thing that we have in our hand is our phone, but it can be turned against us in about 10 seconds flat as one of the most strongest weapons of evidence. Okay? And that's all going to come into play here. Let's see. Hang on one second. Sandy, thank you so much for the $10 on Venmo. She says, Brian, I'm an old lady in New Hampshire and I miss you being on more often. We need you. Oh, I appreciate that. I'm, like I said, I've been trying to work back and get back on a regular. So, okay. So let's move on here. And thank you so much. I appreciate that. And if you want to support me, you can. You can super chat. You can send a Venmo if you want something to stand out. Like I said, super chat there in the chat. We'll pull it up. If you want to send me a Venmo or a Cash App, you can click on the link above that's attached to my chat, and you can support me in any way there. So why does this all matter? So civil discovery doesn't just revisit the criminal record. It widens the scope. Okay. People who avoided testifying in criminal trial to certain things may now face compelled during depositions. The quote, backstage communications, text messages, emails, drafts of reports are far more likely to be exposed. All that butt dial and text messaging and all that shit, you're going to see it all in the civil trial. So in short, expect a much larger universe of documents and testimony in a civil trial, especially when people inside the house that night and from law enforcement, it could also reveal contradictions, suppress details, and potential misconduct that the criminal trial never reached. It's all on the table. It's all on the table. All right, let's move on. Sorry, it's very dry in my house today. So you have the criminal versus civil discovery in the Karen Reed case. So we'll look at criminal first. Criminal trial, what we got and what we didn't get. What was allowed? Liminal discovery under Rule 14. Exculpatory evidence only under Brady Giglio. Witness list tightened, controlled by prosecution, and select digital data, text calls that were filtered by the DA and Mass State Police. What was blocked? Internal police in DA emails and memos. We eventually got some of that. We saw most of that. And we'll probably get more. Broader cell phone extractions, deleted recovered messages, internal affairs, misconduct files, depositions under oath of key witnesses, the Alberts, the McCabe family, and officers that were involved in this case. Someone up here said earlier about be kind. Thank you so much. So this is so informative, Brian. Thank you for doing this. I mean, this is the stuff that I think about, like I sit and I think and I go, okay, can I put this presentation together and kind of just break this down in layman terms, because sometimes this is a big learning experience for me, to go through this and think about it. Let's see. Did I watch the O'Keefe attorney's video on his page. He's a PI attorney, basically an ambulance chaser. No, I haven't seen that. Where did you get that? Email me that. I want to see it. I'll play it tonight. I will play it tonight. So if you have that, Joy, just email me there at letstalklivepodcast@gmail.com. I want to see that. I have not seen that. There's my email address, Joy. If you can send that over, I'll pull it up tonight and we'll take a look at it. Yeah, and here's another good point. Jermaine says all the discrepancies between the grand jury testimony and their testimony in the trials. That's another good point in this too. Oh, thank you, Joy. Yeah, let's pull that up. Let's see. Okay, so let's move on here. So in the civil trial, what will we likely see? So what is now possible? Depositions under oath of Brian Albert, Jennifer McCabe, Mass State Police investigators, Canton first responders. We're going to have full digital records, phone extractions, which is the ultimate most important thing here. Like I said, this thing is one of the most beautiful things that we can have in our hand, but can be turned against us as one of the biggest weapons. If you are involved in any criminal activity, they will find you. And they will find it on your phone. Adam Teeper Legal in the room. What's up, Adam? Good to see you. Very, very good to see you. Okay. Yes, exactly. Digital forensics. No more hiding. No more selection from Mass State Police. No more selection by corrupt DA Michael Morrissey. We get it all. And that's why I say, go back to my initial theme when I started this stream. Are you ready? Are you ready for it? Because they're going to bring it and they're going to want all of it. All of the information is what I mean. So you have full digital records, phone extractions, Google location, social media, and deleted texts. You have internal documents, emails, budget logs, investigative notes, and IA reports. Third-party subpoenas like Verizon, Apple, Ring, Amazon, bar staff, and neighbors. Oh, interesting. How about we talk about that video camera that was across the street that just didn't happen to work that night, right? It didn't happen to work that night. Oh, we lost the footage. Maybe we get some more questions about that. Expanded forensics, all autopsy files, toxicology, pathology reports, cross-examination by both sides. So why does this all matter? Civil standard equals a much broader net reasonably calculated to lead to admissible evidence. No DA chokehold on what comes out. So Michael Morrissey cannot put his greasy fucking fingerprints and hands all over this and control the narrative. It's all going to come out. You have contradictions plus suppressed details more likely to surface, and it forces people who avoided testifying to certain things to speak under oath. To speak under oath. All right. So the bottom line is this. You have the criminal case that was DA controlled, tight scope, many unanswered questions. And you had the civil case that opened subpoenas, depositions, and documents, and it equals potential to expose contradictions, misconduct, and hidden evidence. Okay, so now let's take a look at Brian Albert. So the risk in a civil trial discovery, Brian Albert, deposition at risk. He can't dodge direct questioning about what happened in his house, who was present, what he saw or heard, and what was said after O'Keefe's body was found. His civil liability, if evidence shows that John O'Keefe was injured inside his home, and we all know that they happen, but I just have to talk about it this way. Albert could face liability for wrongful death or negligence. Now, remember, Karen is suing, bringing the Mass State Police investigators that was all involved in this case, along with the McAlberts in this well. Failure to call 911 and concealments. We have credibility issues, all contradiction with prior testimony or refusal to testify in the criminal case locks him into the credibility trap. I love this. I love this. It's all going to come down. So we can't see this shit anymore. We can't see this shit anymore. And I'm going to play some of the testimony from the first trial.
Higgins than you were with John O'Keefe. That's fair to say.
Yes.
On Friday, you were asked whether or not you knew my client, Karen Reed, correct? This meeting a couple days ago. during your direct examination?
I believe so, yes.
You were also asked the same series of questions at another grand jury not involving the Commonwealth. You remember that in June of 2023?
Yes.
I want to be clear about this other hearing. That was a non-Commonwealth hearing in front of a grand jury, correct?
Yes.
All right. Mr. Lally and his colleagues were not there. Is that right?
Yes.
I was not there. Mr. Yannetti was not there.
Yes.
Or Miss Little.
Right.
Okay. At that June 2023, and I'm going to talk about a couple of dates, so I don't want to be confusing. At that June 2023 non-Commonwealth hearing, you were asked some questions about whether or not you knew Karen Reed before January 28th, 2022.
I believe
That's not in question.
I believe so, yes.
And you testified, before you testified, you were sworn an oath.
Yes.
Same oath that you swore in this trial, correct?
Yes.
Swore to tell the truth, the whole truth, and nothing but the truth?
Yes.
And you knew that you were testifying under penalty of perjury in that hearing as well, correct?
Yes.
Excuse
And
me.
you testified at that non-Commonwealth grand jury that you, quote, believe Karen was with John the night he came into Hillside, a female that looked similar to Karen from the waterfall came in with him on that night. And I assume that was her, but I can't say for sure, end quote. That was your testimony before that grand jury.
Yes.
And all
But
this
you were
testimony is going
also
to come in as well, too.
Asked a
The grand
similar
jury.
question in April of 2022 by Mr. Lally at his grand jury. You remember that?
No.
Let's start at the beginning. Before you testified in the April 2022 grand jury, more than a year earlier, and just 3 months after this incident, you were sworn an oath, correct?
Yes.
Same oath that you took in June of 2023, right?
Yes.
And the same oath you took on Friday.
Yes.
So weird seeing Alan without a beard.
Isn't it true that you were asked the question whether or not you knew Karen Reed on January 28th, 2022, and you testified, quote, I've never met or seen her before, end quote.
No, I don't recall that.
Didn't you indicate that you just testified, that you reviewed your grand jury testimony in anticipation for this trial?
Yes.
You'd read the whole thing,
Yes.
and you don't recall making that statement?
No.
May I approach you?
Yes, and I'll see Counselor Tybar when you leave that with the witness.
And here's Auntie Bev gonna step in and start suppressing a bunch of things.
Sure.
And this time they won't have this protection. They won't have this protection anymore. They're going to have to answer the tough questions. I'm gonna speed up a little bit here. Let's go a little bit here.
May I approach you?
Yes.
Mr. Albert, have you had an opportunity to review that?
I have. Thank you.
Yep, exactly. Gatekeeping. Yep.
Does that refresh your recollections to what you said before the grand jury in April of 2022?
Yes, but you didn't read the whole quote though.
Right. The whole quote is the following. Question. So the female you had never met before, is that fair to say? Answer. No, I've never met her or seen her before, period. Maybe once, but I don't think I've ever had a conversation with her. That was the entire quote, correct?
That's the entire quote. Yes, that's not what you read earlier, but yes.
Well, what I read earlier was, I've never met or seen her before. Those words came out of your mouth, correct?
That's not my whole sentence. No.
You said, I've never met or seen her before, and then you said, maybe once, but I've never had a conversation with her, I don't think.
Right. That's my sentence.
Okay, so which is it, Mr. Albert? What were you saying? Were you saying you met her and had a conversation with her? Or were you saying, I've never met or seen her before? Which one of those two things was true?
I was saying that I've met her maybe once.
Actually, what you said was, I've never met her or seen her before. Your words, not my words, sir. Isn't that right?
No, because in the next sentence, I say I met her maybe once.
So you literally changed your testimony within your own testimony.
Objection.
No, can you answer that, Mr. Albert?
I believe I qualified my first sentence with his second sentence.
So what changed between the first sentence, where you indicated unequivocally, I've never met or seen her before, and the second sentence when you said, maybe once?
I'm not sure what I was thinking at the time that I said that.
Isn't it true, Mr. Albert, not only had you met Miss Reed, but you had spent several hours with Karen Reed and John O'Keefe 6 days before this incident? Isn't that true?
No.
Joy, can you do me a favor? Because for some reason my Outlook won't open on my computer. If you have Instagram, could you just send it in an Instagram message to me? And that way I'll be able to get the link. We're not going to play too much more of this because I want to get back to the presentation, but I just want to show you that, you know, all of the bending the truth and lying, you won't have that protection anymore, Brian Albert. You won't have it. You won't have it. You have to answer these tough questions.
Back on January 22nd, 2022, 6 days before January 28th, you socialized with Karen Reed at the Hillside Bar
I hate it, Bob.
for several hours, didn't you?
I was at the Hillside Bar the week prior. Yes.
It was a Saturday night, correct?
Yes.
You were at the bar.
Yes.
There were several other folks at the bar, correct?
Several people. Yes.
That included Chris Albert, your brother,
Yes.
a guy named Tim Daly,
Yes.
Daily, is that right?
I'm not sure how to spell his last name.
Julie Albert was there.
Yes.
Jen McCabe was there.
Yes.
Matt McCabe was there.
Yes.
John O'Keefe was there.
Yes, he was.
And Karen Reed was there. Correct?
Yes, she was.
In fact, Your Honor, may I approach?
Yes.
I'd like you to take a look at a photograph. Just look at that to yourself for a second. Tell me if you familiarize yourself with it, and then look up when you're ready.
Yes.
May I approach?
Yes.
Actually, I don't need to. Mr. Albert, you can stay there. Do you recognize the photograph that's before you?
Yes.
How do you recognize it?
Well, I recognize the people within the photograph, and the background of the photograph looks like the hillside.
Does that appear to be a photograph that was taken on January 22nd, 2022?
Yes.
You were at the Hillside Bar?
Yes.
May I publish this, Your Honor?
Okay, is it already in evidence or
It
you?
is not, Your Honor. I'm sorry.
So you put it in evidence first and then you publish
I
it?
have that marked as next in order,
Yes.
and then
The exhibit 67.
Thank you.
permission to publish, Your Honor?
Yes.
Thank you.
Watch a little
You see
bit
that
more, and then we'll
photograph?
get back to my
It's the same
presentation.
photograph that you're looking at in front of you?
Yes.
Describe who the people are going from left to right, sir.
Chris Albert, myself, John O'Keefe, and Tim Daly.
And this was on January 22nd, 2022, at about 11 p.m., correct?
Yes.
May I approach, Your Honor?
Yes.
Mr. Albert, who took the photo?
I don't know.
Yeah, sure.
Karen Reed took the photo, didn't she?
Yeah.
I have no idea who took that photo.
Yeah.
Karen Reed took the photo. You're literally staring right at her, correct?
I don't know who took the photo.
Well, who else do you think it could have been?
Well, there are a lot of people there. You mentioned my sister, two sister-in-laws, a brother-in-law. I'm not sure.
We can turn the lights back on, please, and take the photo down.
You won't have this protection anymore in a civil trial.
Did you ever see this photo from Jen McCabe?
No.
Did you ever see it from Julie Albert?
No.
Chris Albert didn't take it. He's in it.
Right.
Tim didn't take it. He's in it.
Right.
You obviously didn't take it.
Right.
And who's the guy on the far right?
Tim.
That was Tim. Who's the guy next to Tim?
John. Right?
So who do you think?
Do you still need the photo up? I'm sorry, I thought you were done with it.
Do you remember?
Yeah, it was John. Yeah.
Okay.
He's sweating right
Yes.
now.
Yes.
I don't need it.
Okay.
So given the fact that you were never shown that, you've never seen that photo before today, correct?
I saw a photo that was sent to me in Discovery or to my attorney that showed only, I believe, me and John in the picture.
Okay.
I think it's the same photo, only that's blown up to show everybody.
Got it. So given what you now know about that night, who was there, the fact that John is posing for a photo right next to you, who do you think took the photo, sir?
I have no idea who took the photo.
Could it have been Karen Reed?
Objection.
Sustained. Let's move along from
In
that,
fact,
please.
See, this protection, that protection will not be there anymore. The objection, sustain. Let's move on from this. That won't happen in the civil trial. They're going to have to answer to this. All right, let's pull my, let's see. Joy, no problem. I'll find it at another time and pull it up when I do another one of these. But thank you. I appreciate that. All right, let's go back to my presentation here. So we had Brian Albert. Now we have to look at, the one and only Jennifer Jen McCabe. So we have cell phone and deletion risk, subpoenas for Google searches, deleted text, and full extractions could be expose the discrepancies about her timeline, the Hoslong to die in cold. Okay. Yes, I'm getting ready for those depositions as well. And I want to see the Jennifer McCabe deposition. So she's going to have deposition pressure. Civil attorney can grill her on inconsistencies between her criminal testimony, police interviews, and phone records. And then you have the credibility fallout. If she's caught lying or evading, it damages not only her case, but her entire defense narrative. Okay. Jen is not going to have the protection anymore. Let's listen to a little bit of her testimony from the first trial.
Karen was screaming. My hands were shaking. And she was saying, Google hypothermia. How long does it take to die in the cold?
And what phrase did you put in your phone? I'm just asking you to say it.
Why don't you show me it?
You literally don't remember?
Again, she was screaming, Google hypothermia. How long does it take to die in the cold?
How about?
And I picked up my phone and I started Googling.
And you literally, to this day, right now, under oath, you're saying you don't remember that phrase that you used.
Objection.
I'll allow it.
Is that what you're saying?
I'm saying that at her...
Do you remember it or do you not, Ms. McCabe? That's a simple question.
That morning, I don't remember specifically what I Googled, but I do know what you've put out to the social media.
How about this? Hoslong to die in cold. Does that sound familiar?
Yeah, it's been everywhere.
Why does that sound so familiar?
Because you've put it out in social media.
Well, I haven't put anything out in social media because I don't personally have social media.
I'm sorry, Turtle Boy did.
So if the world happens to know it, that's not on me, is it?
I guess not.
I guess not. Hoslong to die in cold is what you put in to the Google search, right?
If you say so.
Is there a reason that you don't want to admit to that?
Absolutely not.
It's a simple question, right?
It's
no reason.
on your phone.
So say it. What Google search did you use?
Objection.
Sustained.
It's on your phone.
You were seeking at some point to Google how long to die in the cold, correct?
Correct.
And you made a mistake and mistakenly typed Hoslong to die in cold, correct?
You could show me it. I'd appreciate it.
You later Google searched.
All right, let me pause this real quick and answer. In Massachusetts, depositions are not automatically made public. As part of a pretrial discovery process, they are conducted privately and do not become part of the public record unless they are officially filed with the court. I've seen depositions come out after a trial is settled, but they may use some of that in the court if they're filed. When depositions may become public, filed with the court, deposition transcripts and recordings become public if it is submitted to the court as evidence for a motion during the trial. Like I said, if there's specific pieces of the deposition that are brought into the civil trial, it can be made public and be put on the record. So since most court documents are public in Massachusetts, filing depositions placed in it in the public domain, no filing or public access. In cases that are settled before trial or where the deposition is not used in court, the transcript remains a private document shared only among the parties involved. So that is the part about depositions. And if to be said, so I mean, there could be portions that get brought in and played during the trial. Here we go. Let's listen to Jen a little bit more live in the stand. Exactly, Robin.
Thank you.
While she looks at that, Mr. Jackson, can we bring our clerk back upstairs?
Of course, yes. I think we're back to this.
Thank you very much. Can you text Jimmy and tell him?
From your phone, accurate page from a Celebrite extraction from your phone.
It does.
Okay. May I have that back? I'm sorry, may I approach?
Yes.
May I have that back for a second? Did you see this, the actual search phrase? Does
Yes.
that now refresh your recollection?
Yes.
But I'd like to have this marked as next in order.
Is there an objection, Mr. Lally?
No, Your Honor.
Jim?
Lucy, if Jen put her hand on the Bible, it would burn.
May I?
Yes. Is that, Madam Court Reporter?
Thank you.
Move to publish this, Your Honor.
Okay.
All right, here we go. This is the moment. It's the moment that everybody was waiting for. I love it. And this shit will all come in the civil trial. No more hiding. She's going to have to answer these questions.
Does this appear to be the document that was just marked?
No
as
more
99?
protection.
Yes.
I know it's a little bit small, Mr. Basin. You see this column,
Yes.
third column from the, actually it's the fourth column from the left, some dates, some data, and then a Google search, correct?
Correct.
What does that Google search say?
Yes, you can plead the fifth in a
House
civil.
long to die in cold.
Now, you indicate that you did that, you made that search at 6:23 a.m., correct?
Correct.
And then you indicated that you did it again thereafter at 6:24, correct?
Correct.
At 6:24, you misspelled the phrase and you spelled it as follows: how long TI die in CIKD, correct?
Correct.
Now you claim that those two searches were at 6:23 and 6:24 a.m. respectively, correct?
Objection.
Phrase it differently.
Sure.
No
You
more
indicated
protection.
Under direct examination that these two searches were at 6:23 and 6:24 a.m., right?
I don't know if I gave exact times, but I said it was in the morning and Karen had asked me to do it.
And you, exactly, you claimed that you searched it because Karen was screaming at you and yelling at you, Google hypothermia, and you Googled how long does it take for a person to die? I'm sorry, she said something like, how long does it take for a person to die of hypothermia? You Google searched it at 6:23 and 6:24. Is that right?
I still talk about, and I talked about this through the case. That is some of the most preposterous shit that I've ever heard anybody made up. You're in a completely frantic moment. You're a girlfriend of your boyfriend that you've just now found on the front lawn of someone's house that you dropped them off at. There's no one in their fucking clear mind that would look at someone in that moment and go, hey, can you do me a favor? Can you Google how long does it take for someone to die in the cold? That absolutely makes zero sense, because that would be one of the furthest thing from my mind to start thinking about at that point. My natural reaction, just like Karen's natural reaction, was to get out of that truck and run to John to save his life. I don't think in any moment that she took pause and went, oh, I wonder how long it takes for someone to die in the cold. Can you Google that for me? That doesn't make any sense at all. That was the furthest thought from Karen's mind at that point. Exactly, Joy. 100%. No person would do that. It is preposterous. Yeah, and exactly. Hypothermia means low body temperature, not death. Whitey's ghost says exactly. Mary says, how long have you been lying? I mean, there's no way. There is no way. All right, let's play a little bit more of the
Again,
line.
I'm not sure about the exact times. I just did it after Karen asked me to do it.
Would you quarrel with the idea that those were about 30 seconds apart?
Okay.
And you're aware, Ms. McCabe, that both misspellings of that phrase result in the exact same search results, don't they?
I'm not aware of that. No.
Well, you Googled them, ma'am.
I love
On
that.
your phone and you Googled it. How long to die in cold?
I love
How
that.
long to die in CIKD? Both of those. You Googled them, right?
I did, yes.
And they result in the exact same search results. don't
Sure
they?
did.
I have no idea.
So my question to you is, why the two searches?
She was standing next to me screaming, shaking my hand. My hand was cold. I was trying to Google it. Obviously, maybe whatever came up first didn't make sense because I had some misspellings. So I did it again.
So how long to die in cold results in articles concerning dying of exposure, doesn't it?
We never got the chance to read it.
Well, you're the one.
Wait a minute here. I want to see something. Let's just do a little experiment here. So she said that she typed number 3 first, and she got articles that didn't correspond to what she was looking for. So I'm going to Google it right now, just exactly the way that she spelt it. And let's see what kind of articles come up. So we have how long. How does she spell 2? T-I. Die. In. C-K. She spelled it C-K. C-I-K-D. C-I-K-D. I want to go back and listen to what she said. Let's go back.
Google it.
Result in cold results, don't they?
Let's listen.
I'm not aware of that. No.
Well, you Googled them, ma'am.
Right.
You're
Let's
looking
listen
on
to
your
this
phone,
again.
Google it. How long to die in cold and how long to die in CIKD? Both of those. You Googled them, right?
I did, yes.
And they result in the exact same search results, don't they?
I have no idea.
So my question to you is, why the two searches?
She was standing next to me screaming, shaking my hand. My hand was cold. I was trying to Google it. Obviously, maybe whatever came up first didn't make sense because I had some misspellings. So I did.
Okay. So I just Googled it, and the first article that comes up by eMedicine Health, and again, this is a couple of years ago, so I'm sure the search has changed, but emedicinehealth.com, how long does it take to die from hypothermia? That is the first article that comes up, typing it the way that she typed it at first. how long TI die in CIKD. So Google is smart enough to realize the conjecture that you're putting out there, or what you're typing. It's understanding what you're initially trying to say, and it's guiding you towards articles that would go with that language that you've typed. Okay. And again, I'm sure that the search is, but my point is, it is bringing articles up. How long does it take to die from hypothermia? How long does it take for a human to freeze to death? Googling hypothermia. Let's see, hypothermia. Here's how long it takes to freeze to death. How long does it take to get hypothermia in cold water? Those are all things that come up when you type it as how long TI die in CIKD. Now, let's look at, well, now that the Google search, how long to die in cold, we'll type it that way. And it still brings up the first article that I have. How long does it take to die from hypothermia? From emedicinehealth.com. So it gives you the related, and yes, and it does show Jennifer McCabe's photo because now that this has gone through and it's in the search, but her answer is bullshit. That's what I'm getting to here. All right, let's play a little bit more here.
So Hoslong to die in cold results in articles concerning dying of exposure.
We never got the chance to read it.
Well, you're the one, when you say we, who's we?
Karen and myself.
Well, you're the one holding the phone, Ms. McCabe.
Correct.
So you're looking down at your phone and you see exactly what comes up, correct?
I don't remember exactly what came up.
Well, what came up was something about dying of hypothermia, didn't it?
That's
Yep.
what she asked.
I just proved it.
Why do it again? Why do it again, Ms. McCabe? You had the result. Why the second
Right.
search?
I
Right.
cannot answer that beyond telling you that
We're
my
in a
hands were
civil
frozen.
trial.
She was shaking me and screaming at me.
And you see the time, let me scroll up, please. According to the Celebrate data, you see this first search?
Kathy with a $5 super chat. Thank you so much, Kathy, for kicking it off. I appreciate that. $5 says, it just hits me. Karen has never even had a minute to grieve the loss of John O'Keefe. I hope karma is real for these evildoers and what they have done. It's so horrific. I agree. I mean, it's just been after like trial after trial after trial after trial. Not even a moment to sit and actually enjoy your life and grieve and try to move past everything that has happened to you over the last couple of years. And here it is, you know, she's probably going to be wrapped up in this civil trial another 2 to 3 years at least. 2 to 3 years at least. And that's my prediction. And thank you for your super chat. I appreciate that. All right, let's hear Jen do some lying.
It says Hoslong to die in cold.
I do.
What's that time?
2:27.
You've got the, it's right over at 2:27
AM or PM?
a.m.
Ms. McCabe,
Excuse me.
you made that search at 2:27 a.m. because you knew that John O'Keefe was outside in your sister's lawn dying in the cold, didn't you?
Absolutely not. I did not make that search at that time. No.
Realized the next morning, after John was discovered, after 6 a.m., that you had an incriminating search on your phone, didn't you?
Absolutely not.
To cover your tracks, you searched it again in order to overwrite the original search at 2:27, correct?
Again, absolutely not.
Why should you keep looking at the jury? Why are you looking at the jury? What are you trying to do? Influence them, convince them that you didn't do this? Of course you did. It's on your phone. Black and white data does not lie. It's there. And wait till this comes up in the civil trial. Oh boy, you're gonna have a field day.
Nervous, and you screwed it up. So the first search you made at 6:23 was Hoslong to die in CIKD, wasn't it?
No.
When you see the search right there, correct?
I see the search, but I disagree with your narrative.
And what's the time frame of that search?
6:23.
And you agree that that time frame is accurate, right?
Again, it's what the report says.
And that comports with your memory of that morning, about 6:23 in the morning and 51 seconds.
Correct.
There's a second search, correct?
Correct.
And this one at 6:24 says hostile to dying cold. 6:24:16, correct?
Correct.
I'm sorry, 18. I was up that great. And that comports with your memory as well.
I remember Googling it at the request of the defendant. Yes.
About 27 seconds apart, correct?
Yes.
But the reality is your first search didn't comport with the 2:27 a.m. search, did it? It was a different spelling, wasn't it?
I never searched a 227. That is not reality.
But the 6:24 search did exactly mirror the search that,
Right.
according to this report, took place at 2:27, correct?
I'm sure Celebrite will be able to explain it to you. I can't.
And then of those three searches, one of them ended up deleted. Isn't that right?
I never deleted any search.
It's funny. You can't hear Alan Jackson, but you can hear fucking Bev's chair squeaking. That's how bad. And it's funny. Someone just said something about the audio. That's how bad the audio levels are. And it was amazing the other day when we heard the civil hearing. We can actually hear everybody. There's proper microphones inside that courtroom. It's crazy. All right, we're going to play a little bit more here from Jen, and then we'll go back to my presentation.
Take a look at the Celebrite report. Top search. The column marked.
Excuse me.
What do you see?
I see a yes.
Guess what? It was deleted. Yep. And
The reason you deleted that 2:27 a.m. call is because you realized that if you were caught Googling how long it takes for a person to die in the cold 3.5 hours before John's body was found, that would incriminate you, wouldn't it?
Objection.
The objection sustained.
Did you delete that search because you
that
knew
protection goes away.
in John O'Keefe's death if that search was found on your phone?
Objection.
Could you answer that, please?
I did not delete that search. I never made that search at 2:23. I never would have left John O'Keefe out in the cold to die because he was my friend that I loved.
But he's not your family, is he?
Family and friends.
Is he not
Objection.
your?
Sustained.
So keep in mind, all this protection by Lally and Bev, it all goes away in the civil trial. All right, let's move on to back to my presentation. I hope you're enjoying this. If you are, give me a thumbs up in the chat. All right, so we talked Jennifer McCabe. If you haven't subscribed, make sure to subscribe as well. Give that a thumbs up down below. Okay, so we talked Jennifer McCabe. Now we have the MSP. We have Proctor, Bukaki, Guano, internal affairs, exposure, civil discovery can be forced and release the misconduct files in discipline history and prior complaints. So you could dig in now to even the past and get more information in there of any of these officers. You have biased and misconduct risks. Defense attorneys will hammer at Proctor's text messages once again. Alleged conflicts of interest and omission in reports. You have the deposition vulnerability. We'll get that out. Unlike a criminal court where the DA shields them, they'll have to answer line by line and investigative decisions. And then you have the civil liability where it could expose to claims of conspiracy, fabrication of evidence, or malicious prosecution. We saw that obviously in the criminal trial, but it will be exposed even more in the civil trial. Sags, thank you so much. I appreciate that. Thank you, thank you, thank you. Look at this. We have first live. Look at this. Creme de la Crime is at their first live stream today. Well, welcome in. I appreciate it. Yeah. And I don't know why my photo of Guano didn't Guarano didn't load there. So, all right, we'll move on here. So then we have the Canton first responders. And again, my photo didn't load here. Kind of weird. So you have the timeline discrepancies of EMT, fire, police may still face questioning and what they saw at the scene versus what reports said. You have the chain of custody issue. Civil attorneys will scrutinize how evidence, blood, hair, snow, car pieces were collected and preserved. Exposure to negligence claims. If it's shown they did not properly secure a report, what they saw, they can be at risk of tied into a negligence claim, which we saw, obviously, the chain of custody issues, major chain of custody issues in both criminal trials. So, and I don't know why my photos aren't. Let me do this. I'm going to stop sharing this for a second and just reload, because I don't know why these aren't loading. It's getting kind of annoying. Let me refresh. Let me refresh and we'll present again. Let's go to my slide I was at. Oh, there they go. Now they're loading. I just had to refresh the internet. All right. So again, this was the theme when I first started, are you ready? Are you ready? Because you may have to answer some tough questions as well. And I'm talking about the O'Keefes, Peggy and Paul. So now we look at the big picture. The big picture, civil discovery stripes away the DA's shield. These individuals can't rely on prosecutional discretion anymore. Lawyers will be subpoenaed, phones, emails, documents, and demand straight answers. The risk isn't just embarrassment, it's perjury, civil liability, and your reputation can be ruined if contradictions are exposed. And we even saw that in the criminal trial, but it will be even worse civilly. So now we look at the plaintiff risk chart, and this goes to the O'Keefe. So we look at depositions, what could come out. Family members and reps forced under oath, cross-examinations on inconsistencies since 2022. We look at consequences, risk of perjury traps, contradiction, and damaging credibility. You have to look at John O'Keefe's history. We could get medical records, alcohol use, relationships, prior incidences, and it could shift focus to personal factors instead of blaming Karen Reed. Financial claims, scrutiny of dependency, damages, calculations, motives for lawsuits. You could be looking at, hey, Paul, where'd all that money go? Where'd all that money come in? Where did that all go to? Did that go to the back deck in the addition to the house? That could get scrutinized. Defense could argue financial incentive or ulterior motive. And then you look at the counterclaims, defamation or abuse of process if claims are false and misleading, and the consequence of that is exposure to legal liability and financial penalties. You'll get reputational fallout. Evidence contradicting the DA's narrative surfaces in discovery. And then the consequence to that is public credibility, damaging, weakening trust in their case. And finally, loss of narrative control. You have Reed's attorney can present alternative timeline subpoena and new records. And the consequence to that is the story could pivot to events inside Brian Albert's home, undermining O'Keefe's family framing. So the bottom line is this: by filing the civil case, the O'Keefes gain a platform, but also risk losing control of the narrative. The defense lawyers can now pry into areas that were shielded by the criminal trial. And if damaging facts surface, it could backfire on the plaintiffs themselves. Let me just do this. Joy, thank you so much for the 5. We heard Karen screaming on all the audio. She must have whispered to Jen, please Google this for me. It would be funny how the depositions will change during the civil trial. I don't think we're going to hear any of that. Yeah, exactly. She is full of shit. 100%. 100%. And that is actually the end of my presentation. So again, we go back to now this opens up the O'Keefes as well. that could be brought in. I mean, Karen's going to countersue. So goes back to my original theme. Are you ready? Are you going to be prepared for this? Are you willing to show everything? So you've got to be ready for that, And I go back even to when Alan Jackson said outside of court, he said, look, we're always open up to negotiation. So something down the line here could be negotiated. Alan could just turn to Karen and say, look, do we really want to go through another 2-3 years of this? We just pay this and we go away. It's privately settled and the suit ends. I don't know. I don't think that's going to happen. I don't see Karen backing down as much as she didn't back down in the criminal trials. I think that she wants to get it really out there for the public and the world to see all of the things that we weren't able to see in the criminal trials and really expose this group of people for who and what they are. I could see that happening 100%. She just says, you know what? It's all on the table. We continue to keep going through this. I don't care. 2 to 3 years. Let's put all these motherfuckers on trial and just expose them and show everything that they had in every single piece of covering up and helping cover up what happened to John inside Brian Albert's house that night, what happened to John after what happened to John O'Keefe inside Brian Albert's house, and how this was how this was horribly framed to make it look like I did it. Let's just expose them all. Let's expose them all. Why not? Right? Exactly. No quit. No quit. No quit at all. So, let's see. She truly wants justice for him, and that means exposing the real killers. And I truly believe that as well, Karen. But I also look in the sense that this will 1,000 million% clear Karen Read of all time, because there's going to be the naysayers out there, and I think even with the civil trial, with everything comes out, you're still going to always have those people that are going to go, she did it, she did it, she did it. But this is going to now even compile more evidence to prove that she did not do this. And we're going to see the deeper conversations now between all of these parties involved. I'm going to tell you, everything that was protected by the corrupt DA Michael Morsi, you are going to see everything now in the civil trial. I can't wait. I am salivating, because all those conversations that they covered up, the text messaging, the phone calls, everything that has been suppressed in the criminal trials, we're going to get to see it in civil. And I love it. I absolutely love it. I love it. I love it. I love it. Let's see. Albert says, we haven't seen what Karen will do, and I'm sure that she will even have all the lawyers she plans to use to come big on day one. Like, hey, I'm not defending that's pebbles compared to what I'm fighting for. I love that. Love that. So LB says, hey, in a penny for a pound, she's already lost everything. And what does she have to lose? But lots to gain. It's a great strategy. I mean, look, Karen's in the process of rebuilding her life at this point, trying to move past this criminal trial, but now, wrapped up in the civil, but say, fuck them. Like, let's just go. Let's just do this. Let's just show the world. Let's show the world. I love the attitude in here. Nate, no quit. Christy says, hey, bring it on. Why not? Right? Why not? Why not? And look at Joanne says, hey, I think John O'Keefe's dad knows it wasn't Karen. Well, he hasn't been around, right? He hasn't been around. Ed Gein says they should expose who did the video mirror of the Sally Port. I agree. Mary says, given the circumstances, I think we may even get more surprises we didn't know. I think so too as well. 100%. And that's the beauty of a civil trial. It just exposes everything. It exposes everything and exposes everybody for what they are. And it puts it all on the line. So, I don't know. I think that's going to be it. I think that's going to be it for tonight. I wanted to come in and just talk a little bit about the civil trial versus the criminal trial. Hopefully you got some value in this. Please make sure to like, share, and subscribe. Comment down below after this video posts. I would appreciate it. If this is your first time over here, again, subscribe. Turn on all your bell notifications. And I'm going to say this too. If you are not getting my notifications on YouTube, the best thing to do is become a follower of my Facebook page, and I will post that here. Click on that link and become a follower of my Facebook page, because you will get the notifications there. You will get the notifications there. And if you're not getting them here, please do so. And make sure you turn your bell notifications on. Let's see. Tammy wants me to read her above comment. Brian, do you think Karen will look how long her parents have been on this earth after a while, even the O'Keefes, they are in their 70s? Do you think Karen will look how long her parents have on this earth after a while, even the O'Keefes, they are in their late 70s? I'm not quite getting all of that. What you're saying, do you think Karen will look how long her parents have on this earth after a while? I mean, it's just the biggest thing is this, is that, I just feel bad for them. They've been inside courtrooms for the last almost 4 years, and fighting all this. It's ridiculous. It's totally ridiculous. And, to see this happening to them and having them to go through this, and spending their later lives, the later part of their lives inside a courtroom, it's ridiculous. They should be out like vacationing, relaxing, doing whatever they want to do in their yard, taking a vacation, going somewhere, getting some rest. So it's sad. It's really, really sad. So okay, well, I'm gonna head out for tonight. I will be back on Sunday. I'm gonna try to get Todd and Nan on for our Monday spot. We'll probably talk about a lot of the local things that are going on here in the state of Massachusetts. So Pierre de Fullstott says, Brian, Marines Moto, keep moving forward. I love it. What's your name on Facebook? All you got to do is this. Click it here. Click that link there. Join my Facebook page. You'll get all the notifications there. I'm going to head out. I appreciate everybody tonight. I wanted to just keep this one quick and fast. And I'll be back soon. I promise. Just keep a lookout for my upcoming live streams. I hope that you're all getting value in the Karen Reed body cam footage and dash cam footage that I've got. I think I have 1 or 2 more videos that are going to drop in the next couple of days. So you'll have access to all of that. And then you guys can go through all of it. I think it gave a lot of value to people. I think it gave a lot of transparency to people in how Karen was treated and what were the things that was said to her when she was in, when she was in intake. And, that's why I wanted to do that. For full transparency for everybody. And I'll be honest with you, everybody, about 99.9% of the people that have watched those videos, it's been super positive. People want to see this stuff, and it needed to be out there. I did my homework. I did my research. I put in those FOIA requests. I waited almost 7 months to get that, and I wanted it out there. And I haven't heard any complaints from anybody. And again, this could be material that's used in the civil trial. So please go through, look through it, talk through it. That's why I want it there. Share it with your friends. Share it on all your socials, and comment on the videos. So yes, I will talk to everybody soon. I appreciate you popping in tonight. I think Nan is on Calling All Beings, so you might want to pop over there, and they're talking civil trial tonight too. So go over to check out Calling All Beings, tell them LTL Raid, and I'll talk to you guys all soon. Appreciate you, and take care. Bye-bye.